Good morning. Sorry for our late start. This is Bernard Nomberg with the Nomberg Law Firm in downtown Birmingham, and we're back with our weekly Tuesday morning discussions on a brief area of the law that we handle and see all the time. My name again is Bernard Nomberg. Thanks for stopping by. My brother David and I handle workers' compensation cases, Social Security disability, as well as personal injury claims such as car wrecks or any time a person is injured at the fault of another person or another situation. In the last several weeks we've recorded a series of videos that are on our website as well as on our Facebook page, and they've covered a wide range of topics such as what is trial like in a workers' comp case, mediation versus a trial. There's a whole host of them, so feel free to go find those or send us a message if you have questions about those types of matters. Today we're going to talk about idiopathic events in Alabama workers' compensation cases. And what that term in this situation means, an idiopathic event means a situation or an illness that occurs or arises spontaneously or from an obscure or unknown cause. An example of that would be an idiopathic fall, when someone falls and there's no real explanation or no known reason for the fall. And depending on the other factors that may be there, will determine whether or not it's a compensable claim. The key thing is there must be a causal or causal connection between the conditions under which the work is required to be performed and the resulting injury. And the doctrine of these line of cases that have been, many cases have been reported in Alabama in the last 30, 40 years, the general rule is that the employment must be the source and cause of the accident in order for it to be compensable, meaning the person must be in the line and scope of their job at the time that it occurs. And just because someone gets hurt at work while they're doing their job, however, does not mean that it's automatically or necessarily going to be covered. On the other hand, and this is a fact-specific area of the law that can be confusing for most folks, there doesn't have to be a work hazard. There doesn't have to be a problem with the flooring, for example. And most of these case examples are falls, falling from steps, slip and falls on a floor at, say, a hospital. But they can also be from other areas, such as car accidents. And I'll get to some examples in a few minutes. We just have to really prove that the injured worker was in the line of scope of their employment when they got hurt. Most of the time these scenarios are going to be covered. I'll give you one of the examples that we've seen in the past is if someone has a heart attack at work. Well, we need to find out or dig a little deeper to find out, well, what caused that event? Did the person have a pre-existing condition that they were treating or knew about or maybe even didn't know about? And was there any contribution to the employment setting that led to the heart attack or the seizure or whatever it may have been from a medical condition? Let me give you 3 examples of the same similar set of circumstances and tell you what I'm really referring to. Let's say we have a legal assistant who's walking down the hallway and she's got a handful of files in her hand, and she's taking them from one office to another and slips and falls because there's another file that was left in the hallway that someone else had left, and this caused her to fall down and hurt her knee. Well, of course, that's going to be compensable. There was a contribution of the file being in the floor, and she was doing her job at the time she got hurt. That would be compensable. The next scenario was, let's say that file is not there, but she's still walking from one office to the other with the files in her hand, delivering the files, and her foot happens to catch in the carpet, and she falls and injures her knee. We would argue that would be a compensable claim. We would likely take that case. The third scenario is, let's say that let's add the condition that the legal secretary or assistant had prior knee injury, had surgeries and wore a knee brace, and that her knee just gave out as she was walking down the hallway. There was no other factors. The carpet was fine. There was no other foul. It would be that in that scenario, we would argue that it would be denied and be defended based on the idiopathic defense. And they would argue that a prior knee injury. Again, it's questionable. I'm sure it would be denied. We would look at the medical records. We would look at the other factors to see if there's anything else that we could help the injured worker get around this defense. It's not just enough that it occurred in the workplace, but while you're doing your job, did that proximately cause the injury, the accident, the event? And that's probably the key there. Many of these cases, we see them all the time. We see them, if not weekly, monthly, we review those cases. Again, I'm Bernard Nomberg with the Nomberg Law Firm. We appreciate you stopping by for a few minutes or watching this later on. We are in downtown Birmingham, but we handle cases pretty much statewide. Mobile to Dothan to Huntsville to Tuscaloosa to Anniston and in between. We handle workers' comp cases for the injured worker, Social Security disability, as well as personal injury cases. I want to share with you a couple of the case examples we have reviewed in the last couple of months. We had one fellow who came to us who was driving in between restaurants where he was delivering goods. He sneezed while he was driving, and the sneeze, because he had allergies, is what he told us, led to a car accident that he ended up causing. Well, from a personal injury standpoint, pursuing the car wreck claim against the other guy, well, the potential client was actually going to be a defendant because he caused the accident, so we couldn't take that claim. But the workers' comp insurance carrier also denied the claim, even though he was working on the job and doing his job in the line and scope. His pre-existing condition of having allergies is what caused him to sneeze, and that's a very tough case. That's a tough call, so we ended up denying or rejecting or turning down that claim. We had a lady who worked in a warehouse. This was a man who worked in a warehouse around mud and all kind of debris that took him in and out of the warehouse. That claim ended up being he slipped and fell. He had the factor here was he had caked mud and debris all over his boots, and that's what led to the accident where he fell down and had a knee injury. That was compensable, and we took that claim. We're now representing him. Another one where a different lady was working in a warehouse who had several surgeries before beginning employment. This was supposed to be a lighter duty work for her as per her doctor's restrictions from the prior work, but she was clearly doing heavier work, slipped and fell, did not have any reason that she gave for the slip, fall, and accident. That claim was denied. I think we're still trying to decide whether or not that's a claim to pursue. A fourth example I can give you was a nurse who worked at a local, I guess it was a retirement home or a nursing facility, and she slipped and fell while hurrying between one patient's room to another, and she stubbed her toe on the floor and ended up falling and hurting her knee. We ended up taking that case as it's a compensable claim because she was hurrying between patients' rooms while in the course of her job she was trying to get to her next patient so she could administer the care in a timely manner. So that's a claim that was compensable and that we're ended up taking. These cases are they're always fact-specific, whether or not they're going to be compensable or not. They are going to be, if they're denied and we file a lawsuit, they're going to be contested in litigation. There's no doubt. Typically these injuries are going to be pretty significant injuries, but from a fact standpoint, it's going to take a judge to figure out whether or not there really is compensability here. They're tough cases, they're tough scenarios, but it's stuff that we look at, if not weekly, every month. But we appreciate you stopping by. for a few minutes. If you have any questions at any point, please send us a message or call us. Check us out on social media, our website. Again, I'm Bernard Nomberg, Nomberg Law Firm. This is our weekly Tuesday mornings look at the law. Thank you for stopping by, and we hope you guys have a great rest of your day and great rest of your week.